An eviction process in Washington is also known as an unlawful detainer action. The eviction process can differ from county to county, but more or less they're all kind of the same. You start with a clear written notice, you fill out all the forms, you serve the documents, you attend the trial, and then you wait for judgment. Now, while I will be giving you a detailed summary of the eviction process from beginning to end, just remember that I am not an attorney, I didn't go to law school, so while this will be an in-depth video for you, I highly suggest that if you are going through this process, you look for an attorney in your area to help you with your specific case. Now, evictions always begin with an eviction notice. This is a form that's filled out by the landlord, and the notice must detail the tenant's violation and whether or not the tenant can fix the issue. Now, the most common reason for an eviction is the failure to make a timely rent payment. You see, a landlord can evict a tenant for failing to pay the rent on the date that it is due. Rent is generally considered late in Washington a day past its due. However, sometimes there might be a grace period that allows more time to pay rent if it's available and indicated in the lease/rental agreement. Late fees can also be charged on top of rent payment if it's late, if the lease indicates it. But before landlords can start with the eviction action for not paying rent, they must provide the tenant a form that's known as a 14-day notice to pay or vacate. The notice to pay or vacate must inform the renters that they are required to move out of the property or pay the rent in 14 days to avoid eviction. If tenants who are being evicted for failing to pay rent on time manage to pay all the rental payments in full to the landlord before the 14 days are up, the entire eviction process stops and they can continue staying within the rental premises. You see, lease agreements can vary between tenants, and landlords and tenants are both required to uphold the terms of the lease agreement at all times. But you, as a landlord, can evict the tenant for a lease violation. Now, you, as a landlord, must provide the tenant what's known as a 10-day notice to comply, which gives the tenant 10 days to fix the issue. Some common lease violations include damage to the rental unit, smoking in the non-smoking areas, material health and safety violations, too many people living inside the rental unit, or housing a pet in a pet-free zone. So the landlord may continue filing for an eviction lawsuit if the tenant fails to resolve the issue and remains inside the rental unit after the given number of days. Now, that being said, there are some lease violations that are deemed non-curable. These non-curable violations require a 3-day notice to quit, and with these, tenants cannot fix the violation and they are required to move out by the end of the 3 days. Non-curable violations include engaging in criminal activity, being a nuisance on the rental property, hosting an illegal or unlawful business, or creating harmful waste. In the case of illegal activity, a landlord is not legally obligated to give the tenants a written notice. A landlord may proceed directly to the next step in the eviction process. Illegal activities include but are not limited to physical assault that leads to an arrest, possession and/or firing of an illegal firearm, or involvement in the creation, distribution, or consumption of a controlled substance. And a landlord must not hesitate to contact the National Domestic Violence Hotline if a situation escalates or goes out of control. A Washington eviction process does not allow the landlord to evict the tenants without good cause. As long as the tenant does not violate any rules, they can stay there until their rental period ends. However, tenants can be evicted if they stay in the property for even a day after their written lease ends and they have not arranged for a renewal. This type of notice usually only applies if the landlord wants to end the tenant's lease. The required notice time given to tenants is 20 days regardless of their tenancy type. Now, should the tenant remain in the rental premises even after their notice period ends, then the landlord may continue to file an eviction lawsuit in order to evict the tenant from the property. Now, after the notice period has passed, landlords may start to file for an unlawful detainer action to begin the eviction lawsuit. Successful evictions rely on correct filing, so the landlord must file all of the forms correctly. Step 1, proceed to the superior court the rental property belongs to. Step 2, fill out the forms. Step 3, pay the filing fees. Filing fees can go as high as $197 split into a payment plan. A common payment plan is once after filing and then the second after the tenant files an answer or the landlord requests an order to show cause. More payment plans can be arranged at the court though. It takes between 30 and 20 days before a landlord can file a complaint. This really just depends on the notice that was given to the tenant. Now, before filing an eviction with the court, you need to issue the tenant a notice to comply. Now, you can either download a free PDF or Word template of this on our website, or you can use a step-by-step wizard that guides you through the entire process to make sure that you are submitting the legally correct notice. The step-by-step wizard will ask you to pay a small fee at the end, but it is a small price to pay to ensure legal compliance and protection. The last thing you want to do is go to court only to find out that you did the very first step of this whole process wrong. The summons and complaint must be served to the tenant, but the landlord must not serve the document themselves. The document should contain information such as the date and time of the court trial. Washington law allows a sheriff, deputy, or anyone over the age of 18 who is uninvolved in the case to serve the document, and it has to be delivered at least 2 days before the scheduled eviction hearing. The summons and its corresponding documents have to be served through one of the following methods. Personal service, which means the summons and complaint is served to the tenant in person, or a substituted service, which is if the tenant is unavailable and personal service cannot be conducted, a copy of the summons and complaint may be left at the tenant's place of residence or rental unit with somebody who is of a suitable age. There's also mailing service, where the server mails these documents via first-class mail. When using this method of service, a copy is also left with someone else who stays at the same mailing address. Now, in the state of Washington, people being evicted are required to file a written answer within 7 to 30 days from the date that the summons and complaint was issued by the Superior Court. The actual date, however, varies depending on the court's availability. And then once tenants file their answer, a hearing for eviction is scheduled by the Superior Court. Now, should the tenant fail to file an answer, the judicial officer will issue judgment in favor of the landlord without scheduling an eviction hearing. A landlord has to provide a strong argument backed up by solid evidence against their tenant in order to win evictions. Should the tenant fail to show up to the hearing or fail to file an answer, well, then the landlord will win by default. During the court hearing, the landlord has to support their claim with evidence and show it to the judge. This includes but is not limited to the following: a copy of the deed and the lease/rental agreement, rent receipts, rent ledgers, bank statements, witness statements, or photo and video documentation of the violations committed by the tenant. Now, there's no definite time frame for the eviction hearing to be held. It could take a few days up to a few weeks after the tenant filed their answer. It really just depends on the Superior Court's availability. Now, once the landlord wins the case and provided the tenant does not file for an appeal or reconsideration, the court will issue a writ of restitution upon the landlord's request. The writ of restitution is a court order which informs the tenant that they must move out of their housing on the property or else they will be forcibly evicted. And the final step in the eviction process is to move the tenant out of their housing on the property. Now, Washington laws dictate that a tenant has 3 to 5 days to move out of the property, depending on the reason for eviction. If the tenant is being evicted for failure to pay timely rent, they have 5 days to move out upon the posting of the writ of restitution. For all other reasons, the tenant only has 3 days to move out. Now, should the tenant fail to move out on their own by the end of their moving out period, law enforcement officials may forcibly evict them from the property. Repeat after me: a landlord cannot engage in a self-help eviction. The writ of restitution is usually issued within a few hours to a few days after the landlord winning the case. And as I mentioned, the tenant has 3 to 5 days to move out of the property once the writ is posted. So what you're looking at on average is somewhere between 1 and 3 months for the complete eviction process in Washington. Earlier I talked about showing evidence, so let's dive a little bit deeper into that. If the tenant disagrees with the eviction request and they reply to the court, it is important that you keep extremely good records of everything so that you can provide proof to the judge and, well, win your case. Now, this is so important that this can either make or break your entire eviction request in the event of a dispute. So how can you stay organized? So there's a couple ways you can stay organized. One, you can keep a physical paper trail, but this gets a little hard to search through and takes up a lot of storage space and things could get lost or damaged. There are tons of great scanners out there for under the $300 to $400 price range that you can't go wrong with. Which leads me to my next step, which is backups. Store and backup every file you have using things like Dropbox, Google Drive, OneDrive, or any other option that's easily searchable and can easily be stored in a safe place. Or what I think is probably the easiest way is just use a property management software. With these, you can save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, anything you can imagine you can really save in these. And this is best used when you scan every document because you can scan it right into your software. Now, if the tenant doesn't pay rent and they dispute that claim, then it's important that you show the following to the judge. Show them your lease agreement, show them the terms of your agreement, when rent is, and any penalties for a late payment that could be useful in showing the court specifically what was violated. Show them all of your payments, all your previous payments, how they were normally made, and what date they were normally paid on. Show them any payment returns, any checks that have bounced, if their bank account had insufficient funds, or if they had a chargeback dispute on their card. And then show any bank fees that you have been charged and any penalties that you are now owed according to your lease agreement. If you sent your tenant automated or manual payment reminders by text, email, letter, or mail, then it's important to show this as well. Now, it's usually not needed, but it's still good to show that they were aware of the situation and were given the time to cure and make their payments. This is why it's always best practice to have everything in writing instead of just relying on phone calls and face-to-face meetings. So if you're evicting your tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof in form of any of the following methods. Footage from security cameras. I mean, if you have a surveillance system that can show them committing the crime or lease violation, it's pretty safe to say you'll normally win the dispute. But if not, and you still catch them in the act with a video, this is the next best thing. Just record a video with your phone of any damages or lease violations that you can find. And pictures. You know, they say a picture's worth 1,000 words. In this case, it's probably worth $1,000. Now, even if you take a video, it's still important to show the judge any photos that you may have, as it's usually easier to see by email or when it's printed. Once again, show the court which term they violated in their lease agreement. Don't worry if you don't have every single term spelled out on your rental agreement. If the violation is bad enough, it might not need to be written at all. But just in case, it may be worthwhile to specify all of these terms in your future agreements. No. Landlords can be sued for forceful evictions because it is, well, against the law. Consequences can include paying actual damages, costs, and fees, and up to $100 per day that the landlord has shut off utilities. The tenant can only be removed from a rental unit after the landlord has gone through the entire eviction process, and even then, the only person authorized to remove the tenant is the sheriff or constable. Many states have actually made it illegal for a landlord to personally remove the tenant from the rental unit. Examples of illegal self-help evictions include things like changing the locks, taking the tenant's belongings, removing the front door, or turning off utilities like heat and electricity. And actually, a lot of states specify how much money a tenant can sue for if the landlord has tried to illegally evict the tenant through some sort of self-help measure. Washington state law also provides for the tenant's court costs and attorney fees if the tenant successfully sues the landlord and/or gives the tenant the right to stay in the rental unit. According to Washington Civil Code, you may be liable for the tenant's court costs and attorney fees, and the statute also gives the tenant the right to stay. And on top of that, a tenant can sue you for actual damages plus violations. And tenants may ask for an injunction prohibiting any further violation during the court actions. Now be sure to check out this playlist where we go over landlord-tenant laws and see if we've done it in your state, and if not, let us know and we will cover that next. Thank you so much for watching. Subscribe if you haven't already, and I will see you in the next one.